Justice Department was desperate to get this material out and to use it before the election, it looks like, because they wanted all this done by, the first 2 weeks of October or something, just in time for the November elections. Further proof that this was a political operation. So essentially, here's what the Justice Department said is, you have to trust us, Your Honor, on all these records. Even though there's evidence we took material we didn't have a right to have, including hundreds of pages of classified material, medical records of the president, accounting records of the president that weren't responsive even to their outrageously broad subpoena. And this is what the judge wrote. In many respects, the government's position thus presupposes the content, designation, and associated interest in materials under its control. Yet, as the parties' competing filings reveal, there are disputes as to the proper designation of the seized materials, the legal implications flowing from those designations, and the intersecting bodies of law permeating those designations. So what the court is saying is, just because the Justice Department has alleged all of these horrible things about President Trump, the rule of law is I don't have to accept all of that as true. If there's credible information, obviously they're going to take a look at it. But there's been this repeated failure of the Justice Department to reassure the court that they're on the up and up. And further down, she talks about how they're worried that this is classified information and the sooner they get to it, the better. This is like a key part of the ruling in terms of highlighting the Biden Justice Department's corruption. Mindful of the traditional reluctance to intrude upon the authority of the executive in military and national security affairs, so she's referencing the Justice Department's allegations that this material is classified, the court nonetheless cannot abdicate its control over questions of privilege and does not find the government's arguments sufficiently convincing as presented. First, there has been no actual suggestion by the government of any identifiable emergency or imminent disclosure of classified information arising from plaintiffs' allegedly unlawful retention of the seized property. Instead, and unfortunately, the unwarranted disclosures that float in the background have been leaked to the media after the underlying seizure. Boy, that's a judge saying, I think you leaked this stuff. Stop pretending that you have a concern about keeping all of that material sacrosanct. And so as a result, there's going to be a special master. He's going to go through and look at all this. And there's going to be a fight about whether the records are personal or governmental. And, I've talked about that before. I would take the position, strongly take the position that, look, according to the Presidential Records Act, which gives discretion to the president to choose what is personal and presidential, and according to the interpretation of that law by the court's authority at the Supreme Court level, at the appellate court level in the district, and in a key case, the Clinton Software case that Judicial Watch was on the wrong end of, the president, there's no good faith basis to challenge the president's taking of records from the White House. The presumption is that they're personal. So that's what I would be saying to the special counsel. Now they may have, more ifs, ands, and buts when it comes to the special counsel's, the special master's analysis here, but that's the way I think it should go. But I don't know how it will go, because I'm sure the arguments will be more complex, and the president's lawyers will want a little bit more nuance, as they might say. And of course, what the Justice Department is going to be doing. But the important thing is that this will mean the case won't be resolved one way or another unless there's appellate intervention until the end, I think, of November. So the Justice Department was desperate to get this material out and to use it before the election, it looks like, because they wanted all this done by, the first 2 weeks of October or something, just in time for the November elections. Further proof that this was a political operation. So you have the leaks designed to make Trump look bad, designed to intimidate the court. proof that it's a political operation. The desire to get, quote, this information that's been supposedly sitting in the president's home for a year and a half, that became an emergency all of a sudden, and they needed to get it done just before the election, further proof it's a political operation. The attacks on the judge, further proof it's a political operation. This is not about the rule of law. This is a political raid by an out-of-control Justice Department and the FBI. And if you want proof of that, read the judge's ruling. You don't have to be a lawyer. All you have to be is someone with enough sense to see that there's a federal court judge who's fed up with this Justice Department, fed up with this FBI, and she's not going to be bullied by them into blessing something that on its face is suspicious. So this is how the court concludes. It's important, I think, that you hear this. Lastly, the court agrees with the government that the public is best served by even-handed adherence to established principles of civil and criminal procedure, regardless of the personal identity of the parties involved. It is also true, of course, that even-handed procedure does not demand unquestioning trust in the determinations of the Department of Justice. Based on the nature of this action, the principles of equity require the court to consider the specific context at issue, and that consideration is inherently impacted by the position formerly held by the plaintiff. The court thus continues to endeavor to serve the public interest, the principles of civil and criminal procedure, and the principles of equity. And the court remains firmly of the view that appointment of a special master to conduct a review of the seized materials accompanied by a temporary injunction to avoid unwarranted use and disclosure of potentially privileged or personal materials is fully consonant with the foregoing principles and with the need to ensure at least the appearance of fairness and integrity under unprecedented circumstances. Now, who would be opposed to that type of analysis? Anti-Trump fanatics. The Garland Justice Department, which is completely out of control. Now, this ruling, ironically, wasn't a perfect victory for Trump because the judge says, well, you can brief Congress, potentially in some of these records. So you can bet the Justice Department is going to use that to leak material to people like Adam Schiff up on the Hill. So I suspect that's going to be the next scheme pursued to misuse these documents. Again, further confirming that it was political. Let's go raid someone's home, give it to Congress. We're not allowed to talk about it, but once we give it to Congress, all bets are off. It's going to get out there. So this was a big victory for Trump. So what else is going to happen? Now there has to be a decision as to whether there's going to be, by the Justice Department, whether there's going to be appeals. That may delay things if they decide to appeal. But in the meantime, there's a special master appointed, and the process will continue in a way that ensures better, it's never perfect, but more accountability and more transparency and better protects the civil rights of President Trump. Because the left is angry that the court is worried about the civil rights of President Trump because they don't believe President Trump should have any civil rights. At least that's the way they behave. And on top of that, of course, Judicial Watch will continue its separate independent investigation of this improper raid. We already have a lawsuit about targeting the National Archives over records it has that relates to the raid. They're hiding records, so there's lawlessness there. And there's a whole host of other Freedom of Information Act requests that we are looking at suing on because they continue to ignore the rule of law there. So while at the same time as telling the courts and the American people that there's this core concern that they were trying to vindicate to make sure that records about what the government was up to, specifically as it relates to the President Trump's White House, that those be preserved so they can be shared with the American people, they are specifically ignoring the law requiring the shared documents about this scheme with the American people. Further indication that this is political. And it's up to, frankly, Judicial Watch to step in and do the heavy lifting to figure out or to get more of the truth about what's going on.
Thanks for watching. Don't forget to hit that subscribe button and like our video down below.